Thank you. Good afternoon, colleagues. Appreciate your consideration of AB 2819, which would protect tenants from unfairly being placed on tenant blacklists, which would jeopardize their credit and ability to obtain housing. Let me first begin by accepting all of the committee amendments and thank the committee staff for their good work. Under current law, court records in eviction lawsuits, otherwise known as unlawful detainers or UDs, become public after 60 days unless a tenant wins before the deadlines. UDs are supposed to be heard within 20 days of filing. However, we all know that following severe budget cuts and court closures after the Great Recession, state delays in our judicial system have often pushed hearings well beyond the 60-day mark. The most recent data from the Judicial Council shows that a record 1/3 of UD cases remain unresolved at the 45-day mark. Now, why is this a problem? After the 60-day mark, the tenant's information is automatically made public, even if they are eventually never evicted. In other words, they are found guilty before being proven innocent. Companies capture and publish these lists of tenant names, information that remains on a tenant's credit report for up to 7 years, jeopardizing credit and one's ability to obtain housing. Even if the tenant eventually wins her case after 60 days, or is named in an eviction lawsuit where a landlord ultimately decides not to pursue the case, she would still end up on a tenant blacklist. Landlords are unable to distinguish between problematic and innocent tenants, so they screen out innocent applicants. The affordable housing crisis that we are all very familiar with is then exacerbated for thousands of innocent Californian families in competitive housing markets around our state. Just to give an example, in San Francisco, we're talking over 500 UD lawsuits not heard until after the 60-day mark. In San Diego, that number is 1,500 UDs that are unresolved past the 60-day deadline. In Los Angeles, we're talking about 6,000 eviction lawsuits after that deadline. Our bill would prevent the blacklisting of innocent tenants whose credit and reputations could be ruined by requiring that court records remain sealed unless the landlord prevails in the eviction lawsuit within 60 days of filing. I want to just take a moment and mention that my staff and I have worked hard to address stakeholder concerns to balance the protection of families while ensuring landlords have access to timely and accurate information regarding prospective tenants. We've taken a series of amendments based on conversations and comments received from the California Apartment Association and believe we are close to a final compromise. And we've made sure that our language in the new bill tracks the old, to also allow parties to stipulate to masking without making it mandatory on a court or a landlord, and to allow landlords to pursue evidence at UD trials regarding so-called serial abusers. I'm also committed to working with the regional apartment associations to address the concerns they may have as this bill moves forward today. And let me just finish by saying there's nothing in current law or this bill that would prevent a landlord from requesting references from a prospective tenant's past landlords. With that, I'd like to turn it over to our witnesses.
Thank you. First witness, please. I'm going to allow 3 witnesses.
Thank you, Mr. Chairman and members of the committee. My name is Jith Meganathan. I'm a policy advocate with the Western Center on Law and Poverty. The motivation for this bill is simple. You shouldn't lose your ability to find housing simply because you're sued in an eviction lawsuit. But that's exactly what happens under current law. You're going to hear from Ms. Andia Cleveland. She and her 6-year-old daughter were homeless for months, even though she was never found guilty of unlawful detainer. The legislature has made addressing homelessness a priority this year. Here's a way to reduce homelessness by amending a single statute. 90% of tenants are unrepresented in UD proceedings. Many of those who are represented are so afraid of ending up on tenant blacklists that they give up their legal rights. You're also going to hear from Ms. Denise Barton, an experienced trial attorney. Rather than fighting the legal eviction, one that violated fair housing laws, she moved out just to protect her credit. This is a bad law, and it's badly in need of reform. I'll now turn to Ms. Cleveland and Ms. Barton, who speak for thousands of other tenants.
Thank you. First witness, please, or next witness.
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Denise Marie Barton. I work for an attorney for the federal government. I've been a trial attorney for over almost 20 years now. For the record, I want to make clear very quickly that I'm here in my personal capacity. I'm not representing the United States, and I'm not here in any capacity on behalf of the United States. In fact, I took annual leave, very valuable vacation time, so that I could be here today to address this issue that very, very significantly impacted my life and the life of my 14-month-old twin daughters. The reason I mention my profession is in part because I am the person in this room, and that most people think should be able to navigate and manage an unlawful eviction. I'm educated. I'm a lawyer. But with the law as it now stands, I could not. I couldn't take the risk that my very solid credit rating would be marred because I might not prevail within the very limited portion set forth in the current law. Last year, I hit a true high point and a true low point, a rock bottom low in my life. And the current law regarding the reporting of unlawful detainers is what brought me to that low point. Until last year, I lived in San Francisco, a city I love. I'd lived there for about 9 years. I'd built a community, and I'd worked for the community there. After struggling for about 4 years with infertility, last February, my twin daughters were born. That was the very, very high point of last year for me. 4 weeks later, while I was still very, very ill and trying to recover from a very complicated pregnancy for which I'd been hospitalized, my landlords, who had been friends and who had known about my medical situation, began engaging in harassing efforts to force me out of my home. That didn't work. When my daughters were 2 months old, they started engaging in further pressure. They called me and told me they were selling the property and told me that I had a choice, either leave within 30 days or take the chance that the new owner would rent to me. As a single mother to then 2-month-old twins who was still very ill and dealing with typical new parenting challenges that many of you probably have dealt with, I couldn't move on that 30-day time schedule that they set for me. So I chose my only option, to stay and hope for the best with a new owner. I also emailed these people because they'd been my friends, and I expressed hurt and confusion, about their actions. They told me that they would not have rented to me if they'd known that I was intending to have children, and that they had chosen not to rent to other people because they didn't want children in the apartment. I knew that was legal. That was not legal, I'm sorry. So I found a well-regarded tenant lawyer, and I spent thousands of dollars to try and help with my situation. It didn't work. My landlords tried several other increasing tactics to get me out that were frankly harassment. They falsely claimed I didn't pay rent. They gave me a 3-day notice to vacate. They claimed I created safety hazards, which I didn't do. And finally, when my daughters were 5 months old, they served me with a 60-day notice of termination. In that notice, they said if I didn't vacate, I'd be liable for unlawful detainer damages, costs, and face a lawsuit. That is what brought me to the rock bottom low, and it still obviously gets me emotional. I knew from the months of their increasing harassment, the email in which they said they wouldn't have rented to me if they'd known I was having children, and I'm wrapping up, Mr. Chairman, that their move was based on my having children. But I also knew I couldn't successfully contest and complete an eviction period within the 60 days based on my knowledge and what my lawyer told me. So I chose what I had to do to protect my credit and my children. I took my children when they were 5 and 7 months old and had to scour every rental listing in the Bay Area and carry my twins in and out of 70 apartment rental viewings before I could find somebody who would rent to a single mother with twins. I stayed up nights and days crying because I was afraid I'd be homeless. I had to leave San Francisco and move to a community in which I didn't know anyone. I lost my support network. I had to leave the community I'd practiced law in and move to another community and try and build a reputation there. All this because I couldn't risk damaging my credit and hope that someday I could rent again or perhaps buy a home. I'm sorry. So I urge you to vote yay. It's a change that will protect countless people like me who are faced with an impossible choice for them and their families. I had to fight. I could either fight an unlawful eviction and ruin my credit or succumb to illegal landlord tactics that were because I had children, uproot my home, really affect my career, and move from my home and community. I thank you, and I apologize.
Thank you. Next witness, please. And I'm trying to allow for testimony, but if you could please fit within about 3 minutes. Thank you.
Good afternoon. My name is India Cleveland, and I am a proud resident of Oakland and the mother of a 6-year-old daughter. I thank the community for the opportunity to be here. In May of 2009, I was named as a defendant in an eviction lawsuit. I responded immediately by filing an answer with the court, but no further action was taken in the case. During that time, the landlord lost the property in a foreclosure, so soon after I moved into another apartment in Oakland. At that time, I believed the lawsuit was over. After all, the landlord was no longer the property owner. I had moved out of the apartment, and there was no indication from the court at all that the lawsuit was ongoing. But that was not the case. When I began looking for a new apartment last fall, all of my applications were being denied. More than 10 applications were rejected in a few short months. When I asked why, I learned it was because of a 2009 eviction lawsuit. It had showed up on my credit report as well as in public records. And though I was never actually evicted, I also learned that the lawsuit was still pending in the court more than 6.5 years after it was filed. As a result, I wasn't able to find housing for over 6 months, and in that time, my daughter and I relied on family, occasional hotels until we eventually were homeless. We moved around so much that my daughter asked me each night where we were going to sleep. It was only a few weeks ago that I finally found an apartment in May of 2016. Before 2009, I had never been involved in an eviction lawsuit. I've never been evicted and have not been in one since then. The current law creates a domino effect that's difficult to come back from. If the chair members take nothing else from what we're saying, please understand that when the court dates are over and the landlords go back to their everyday lives, the real hard work is just beginning for us. We now have a tremendously difficult and timely and costly bill of trying to rebuild for our lives and our family. And the passing of this bill is just another step to ensure that every family has the access to stable housing that we may take for granted. I support this bill because I don't want any family to go through what my family is still going through 7 years later. Thank you.
Thank you. Anyone else in support? If you could just give your name and affiliation, please.
Brian Augusta on behalf of the California Rural Legal Assistance Foundation in support.
Kevin Baker, American Civil Liberties Union, also in support.
Sylvia Solis Shaw on behalf of the City of Santa Monica in support.
Thank you. Anyone else in support? Right. Opposition? In between? Let's take the in between first.
I'm the in between. My name is Deborah Carlson with the California Apartment Association. We're now in a neutral position. I want to thank the author for taking our amendments. Our concerns surrounded. Pardon? Our concerns surrounded the delay tactics that we didn't want to create as a result of any amendments. So the author has taken 2 amendments to deal with our concerns about some of the abuses where some defense attorneys ask for a trial simply to delay an eviction. In those cases will be unmasked if the landlord wins, even if it's after 60 days. And then the amendment number 2, in those cases where we have a defense attorney who unethically uses delay tactics over and over and over again, a property owner can gain access to cases that would be otherwise masked to the general public to make a case that that there's a negative practice that's going on. So we think we fixed those 2 concerns that we have about delays and yet allowed the tenants who have been unjustly have problems looking for housing thereafter. So thank you.
Mr. Pone?
Chair and members, Dan Pone for the Judicial Council. Although we don't have a formal position yet, we've been working with the sponsors, as we have with the earlier masking bills, to make sure that the masking provisions are as workable as possible for the courts. We've worked from the very beginning on language to try to ensure that, and we look forward to continuing conversations as we engage in further reviews of the bill to the extent that there might be any additional tweaking that's necessary. Very much appreciate your cooperation.
Thank you. And could you make room for the opposition, please?
Okay, go back. So much.
Thank you, Mr. Stone, members of the committee. I'm Ron Kingston, representing 4 apartment associations: Apartment Association Southern Cities, Orange County, East Bay Association, and the North Valley Association. First, let me start off by talking about some of the very situations that one of the witnesses discussed. There were several elements that were allegedly illegal. In one case, as was cited, the landlord engaged in harassment that is illegal in San Francisco by a San Francisco ordinance. It is illegal under state law. 2, the discussion about discrimination, that is illegal specifically by ordinance in San Francisco and in state law as into the California Fair Housing and Employment Act. The discussion was also by providing a 60-day notice. Illegal in San Francisco. It is a rent control and just cause community. So there are remedies, and there are a number of entities there, the Eviction Defense Center, and a number of other entities that do offer specific assistance for very clear illegal activities by a landlord. Now, to the bill. First, let me set the stage. There is no other creditor that we are aware of that is required to continue to extend credit when there is no paying or a slow pay under and pursuant to an agreement. In this case, a rental agreement or a lease agreement. You pay $1,200 a month, $1,500 a month on the first. You know it specifically. And when there is a dispute that arises, what happens in that situation is either the landlord prefers to go and approach the tenant or is forced to then file an unlawful detainer. That unlawful detainer doesn't come cheap. Filing fees are a minimum of $385 just with the court. There is a suggestion that we should take it to judgment. We have heard this many, many times. To take it to a default judgment is a minimum of just $500, and that is another fee. Landlords face unlawful detainers. There are thousands that are filed every year. And the issue that we're trying to bring is landlords don't frivolously bring unlawful detainers. It's way too costly. They never, ever recover the amount that is due in dispute.
I need you to conclude, please.
Okay. Thank you, Mr. Stone. So the issue here is this bill, number one, could cause the reverse effect. It says it has to come to judgment in 60 days. There are a number of eviction defense firms that will be encouraged to push the unlawful detainer dispute past 60 days.
About another 15 seconds.
That's one. Okay. Number two, there is the issue about this is the way the real world works. The real world works is very few are taken to judgment. Most of them are stipulated.
Thank you.
Stipulated judgments. And can I just finish my sentence? Or?
Finish your sentence.
Okay, thanks. Most are stipulated or the court stipulated judgments, and that's what really happens in real life. We believe that this is excessive. Thank you.
Thank you. Next witness, please.
Mr. Chair and members, Steve Carlson for the Apartment Association of Greater Los Angeles and the Santa Barbara Rental Property Association. Our concern is sort of a broader kind of a global concern. We certainly understand that there are instances where things like this can slip through the cracks, and people who may not specifically kind of fall within the specifics of the law might get something on their credit, and those are unfortunate things, and hopefully we can focus on that. On the other side, by sort of flipping the burden in this instance from one that had been around for a long time, I don't think one of the things that has been brought up is that, and you've heard about it before, I think we talked about it a week or two ago, and we're going to hear about it next week in connection with another bill, that if you kind of guess wrong and you aren't aware of the information you should have when you're making a rental decision, you can be put into months and months and months of a very, very difficult experience. We've heard about we think, extortion, use of the jury trial option, and a few other things. So owners deserve to have the information that if someone has had a bad track record. And unfortunately, we don't see the balance here, and I know Mr. Chu is trying to get there, and I think the amendments that you discussed can move us forward a little bit. But we're still concerned that from our members, who are mostly small folks, if they get into this system and they say, "Oh my goodness, getting out of it's really tough and very expensive." So that's why we'll certainly continue to work with Mr. Chu and the sponsors of the bill, but we're not quite there yet.
Thank you. Anyone else in opposition? If you could give your name and affiliation, please.
Jennifer Tannehill with Aaron Reed and Associates on behalf of the San Diego County Apartment Association in opposition.
Thank you. Anyone else in opposition? Seeing none, we'll bring it back to the committee. Questions, comments? Mr. Gallagher?
So, Mr. Chair, I just wanted to run through, with the amendments that you've taken, I wanted to run through a few scenarios. I think everybody agrees that, in the case of the ladies who testified here, we don't want to allow that to happen, right? But, the vast majority of unlawful detainers are when somebody has, broken their lease and they're bringing the unlawful detainer because there's been a breach of the lease. There's either been a non-payment of rent or otherwise, and I do think they're not taken lightly in most cases by tenants because they are expensive to bring an unlawful detainer, and you may not ultimately get all of the back rent, and they settle a lot. So they're usually settled. They're not always. I think it's very rare. Just like most cases in our courts aren't taken all the way to trial. So under the scenario of a tenant gets an unlawful detainer action against them and they just don't contest it at all and a default judgment is entered against them, in that case, they would not be masked.
In that case, they would be on the tenant blacklist.
Right. In the case that...
and which I might say, I know it was suggested that is unfortunate. Colleagues, we know if any of us were on... it's more than unfortunate. This is something that could severely impact your economics and prevent you, as you heard, from being able to find another place to live.
Right. In the case where they reach a settlement and they stipulate that the tenant was at fault, then they would also not be masked. Is that right? If there's a stipulation of that effect.
If they stipulate, it could be masked, but that is up to the parties to agree. And in fact, the original language had made it a little more clear that a court could require the masking of it. We were asked by the Apartment Association to loosen that language so that the landlords wouldn't be forced to enter into that stipulation and forced to enter into that permanent masking. So at the request of the Apartment Association, we've made it permissive, something that they could enter into.
Okay, what if they settle and they don't stipulate? Then what would happen in that scenario?
I probably have to ask some of the experts, but generally if you settle, I think there's typically an agreement around a stipulation.
Sir, so your situation is that there's a stipulation and the stipulation states that the tenant is liable for unlawful detainer?
Right. Well, they wouldn't usually do that.
Or that the tenant is at fault?
What if there's no stipulation at all? They just settle within 60 days. Is there a masking or not a masking?
Under current law, it would be unmasked. Under the bill, I believe it would be masked since there wouldn't be a finding of liability on the part of the tenant.
Okay.
It wouldn't say unless the stipulation said the landlord is the prevailing party or the tenant was liable for unlawful detainer. So the stipulation would have to have some language addressing that.
Right, and you're saying under current law, it would be unmasked?
Unmasked.
If there was a settlement?
If there was a settlement and there was no, I'm sorry.
And no finding of liability, there's just a settlement?
Correct. Mere involvement in an unlawful detainer lawsuit being named as a tenant right now is unmasked after 60 days.
Right. Okay. And then in the event that you go to trial and there's a judgment in favor of landlord within 60 days, unmasked under this bill?
Under a current law and under this bill.
Okay, but what if after more than 60 days, but you still get a judgment in favor of a landlord? Unmasked or masked?
Under this bill, currently masked. We're in discussions with the Apartment Association about how to address that situation.
So I think that's one where I'd have a big question, because ultimately, if they win the lawsuit, they win the unlawful detainer, and the court finds that they were right. And sometimes these do take. I think anybody who's been involved with these know they don't always just resolve in 60 days. So it could take longer than that, depending on what court you're in. Shouldn't there be a provision there that, hey, if you're found to be liable, ultimately you shouldn't be masked in that case, right?
So And that's precisely the concern that the apartment association raised, and we've been working diligently to find a solution that's acceptable to them and is still sound public policy, and it's for that reason that Ms. Carlton said that they were neutral at this time.
Okay. That's all the questions I have.
Other questions, comments? Mr. Ting?
Just a quick comment. I'm very much in support of this bill. I know this is a real issue. Given the severity of the blacklist, I think we have to make sure that people who are actually going on that list have actually committed what the blacklist is meant to be. We've all been victims of our credit reports where things accidentally get on our credit reports and we don't anywhere have to deal with those kind of consequences. The consequences are nowhere near as severe, yet all of us, I'm sure, at some point or another have had to take off erroneous things on our credit reports, which may impact our ability to get a loan. Obviously, I think this blacklist is even much more severe, and given the number of evictions in LA and in San Francisco, which my colleague from San Francisco stated, I think it's really important that we make sure this list is actually as accurate as possible, so it doesn't really do harm to people who are just there by accident or there erroneously.
Ms. Garcia.
I want to thank the author for working and taking amendments from the Apartment Association. So I do want to acknowledge that. I do think, though, that the idea that we have large apartment owners and small apartment owners and different ways in which to deal with, or different levels of sophistication in which to deal with, needs to be finessed a little bit more as this bill moves forward. I've spoken to you. You're trying to find that sweet spot, and so I am going to vote for today's bill. But before I could vote for this in its next iteration, I'd like to find that sweeter spot. I think the reality is that on both sides, the list isn't perfect for either side, and I think you're trying to make it fair. And as you're making it fair for tenants, making sure it's fair for the other sides. And I think you've done a lot in your amendments to make sure you're trying to get that spot today. But I do have concerns. Sometimes you will have landlords to settle because it's taking 6 to 8 months to even get a court date going on in this LA. And so we're sitting there thinking about the reality of what you're losing. You're like, let me just settle. And you might settle without putting who's at fault, not think about it. It's not in there. And someone that maybe should have been on the blacklist is not on the blacklist. So I do think that we need to think about that. I appreciate your commitment to try to find that sweet spot, and I appreciate the reality of San Francisco or downtown LA, neither of which I live in. But I do live in the reality where I have 15,000 apartment units in my district, and less than 500 of them are in plots that have 6 or more units. So most of them are these smaller smaller dwellings. So it's a little bit different. Thank you.
Are there questions, comments from members? All right. So we do have a motion. Is there a second? And a second. All right. Mr. G, you may close.
Thank you. First of all, colleagues, I appreciate your consideration of this issue. I know many of you have spent quite a bit of time thinking about it. I think Ms. Cleveland and Ms. Barton really told the story, which, again, as I said, in San Francisco, we have about 500 of these UDs that have not been resolved at the 60-day mark. In Los Angeles, 6,000. Alameda County, almost 1,500. San Diego, 1,500 as well. And I would hope, as Mr. Kingston had pointed out, that we don't have landlords who are engaged in harassment or discrimination, but the fact of the matter is we do know that does happen. And in that situation, we also know that 90% of these individuals are not represented. Unfortunately, if we had all the resources in the world, these individuals would get the representation that I think they need. I think we all would agree with that. But when faced with the choice of knowing that if by 60 days you could be on a blacklist that could impact your ability to get a job or to have credit or to have housing for the next 7 years or to move out, it's a very stark choice. And I do think this starts to strike the right balance. That being said, I am committed to working with the Apartment Association and the regional apartment associations to see if there are other solutions here that fine-tune that balance. I know that our sponsors are committed to that as well, and that's my commitment to you. So appreciate your consideration and ask for an aye vote.
Thank you. So the motion is do pass as amended. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
No.
Wagner, no. Alejo? Alejo, aye. Chow? Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
I'm going to lay off today, but I do want to work with you on. I mean, I appreciate that you're taking the amendments and that we're trying to work through some of these details. So I want to lay off today, but I would like to work with you down the road.
Thank you.
Garcia? Aye. Garcia, aye. Holden? Aye. Holden, aye. Mainshine?
Not voting, but not editorial.
Thank you, Mr. Mainshine.
Ting? Ting, aye.
That bill is out.
Thank you, colleagues.
Thank you. All right, members, let's go back through the list. We do have everyone here. And so we have some. Do you want to do the on-calls first, or do you want to just go through the list? We're going to go through the list in order. Some bills are on call, some are not, but let's get everybody on. So item number 1, AB 1723, Dodd. Chair voting aye.
Alejo? Alejo, aye. Garcia? Garcia, aye. Holden? Holden, aye. Ting? Ting, aye.
Right. Then item number 2, AB 2300, Wood. Chair voting aye.
Alejo? Alejo, aye. Garcia? Aye. Garcia, aye. Holden? Aye. Holden, aye. Ting? Ting, aye.
Item number 3 we just did. Did you get everybody on?
No.
I'm sorry, this was, okay, item number 3, AB 2362, Kansen-Chu.
Alejo?
Chair voting aye.
Alejo, aye. Holden? Holden, aye. Mainshine? Mainshine, aye.
Okay. Item number 4, which is on call, AB 2667, Thurmond. Chair voting aye.
Alejo? Alejo, aye. Holden? Holden, aye. Mainshine? Mainshine, no.
That bill is out. Item number 5, which is on call, AB 2748, Gatto. Chair voting aye.
Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, no. Garcia? Garcia, aye. Holden? Holden, aye. Mainshine? Mainshine, no. Ting? Ting, aye.
That bill is out. Item number 6, also on call, 2755, Gallagher. Chair voting aye.
Alejo? Alejo, I guess aye. Chu? Chu, aye. Garcia? Garcia, aye. Holden? Holden, aye. Ting? Ting, aye.
That bill is out. Item number 7 we just did. You've got everybody on. Item number 8 is being held. Item number 9, 2878, the judiciary bill. Chair voting aye.
Holden? Holden, aye. Ting? Ting, aye.
And our final item is item number 10, AJR 30, which is also on call. Chair voting no. Call the absent members, please.
Chow? Chow, no. Holden? Holden, no. Ting? Ting, no.
Then that fails. Consent. Call the roll, please.
Alejo? Alejo, aye. Garcia? Garcia, aye. Holden? Holden, aye. Ting? Ting, aye.
All right. That concludes our business for today. Thank you all very much. We are adjourned.